to HOA SOS. We're so glad that we're here and able to present a new topic to you. Wes, it's great to see you. Looking fantastic. This topic we're dealing with is one that's close to your heart. We're now getting into the rainy season. Just because the sun is out, it doesn't mean that it doesn't hold dangers to our communities.
You're right. It means hail season.
It is hail season.
In addition to rain season. Hell yeah, we call it at the firm. What Lee's getting at is one of the complex HOA litigation areas that we practice in is we help multifamily communities with insurance recovery. And I would say like 80% of what we handle, fair to say, Lee, insurance-related claims due to wind and hail damage.
Absolutely.
So it's always on our mind, especially this time of year.
Right. And with hail, there's been a lot of cases that have, and I'm talking about, trial level cases, federal, state, in Colorado over the last year and a half that we're concerned with, we think associations should be concerned with, but really very little appellate case law that has come out that's to be helpful.
Right, you are, Lee. It's an open landscape. So the issue we confront today, the Mayday, is we get a call from a community that said they had a hailstorm last year. They filed their claim. They've got easily between roof, decks, gutters, downspouts, things like that took large scale hail hits. They've got about a $1.2 million insurance claim. And this isn't the classic dispute where the HOA says that's our damages and the insurance carrier says, nah, it's just the amount of your deductible. You just need to fix a few tiles, and you say it's replacement, we say it's a fix. This situation where the carrier just denied it. And why did they deny it? Because they said under the policy that the condo community didn't report the hail claim soon enough. So we thought we'd talk about that today and then try to give our listeners some advice about how to avoid this situation if at all possible. And it really stems from one of our oldest clients in a big case they had. And happy to talk about that case because it's public record now. Federal case went up to 10th Circuit Court of Appeals, our client's Sunflower condos. One of the tough issues with wind and hail that's out there, and we really feel that it's a very complicated, Mayday issue, help us, is this issue where the carrier may deny a claim. Why? Why did that happen, Lee? Why do carriers just say we're not going to cover your loss at all? What's one of the big shields they use to not cover something under a covered cause of loss in the insurance policy?
Yeah, for a number of reasons, but the biggest one is they argue improper timing.
Yep, exactly.
And so with regard to timing, what's the language? It's typically in the insurance policy that's become a big issue, a big firestorm here.
Yeah, this was a huge issue for our client and relates to this general issue. Most commercial line policies, especially ones associations have, has a policy provision called prompt notice or timely notice, something along those lines. And the general gist of it means that you as the policy holder, if you're a multifamily community, you got to report something like a hail storm loss within a reasonable period of time. But gee, do you think the policy language defines what's reasonable?
Yeah, it's confused our Article 3 judges as well. We have seen over the last couple of years just decisions all over the place as to when reasonable notice or prompt notice occurs.
Yeah, all right, so let's break that down. Lee mentioned an Article 3 judge. What on earth is that? Sounds like somebody who's a judge but a journalist or something like that. But you know what? It's a federal judge, right? And you and I have a federal court background. And so these insurance cases, how the heck do they get into federal court? We file them on behalf of our clients in state court. But as Lee can tell you, they end up in federal court under something called diversity. Why do the insurance carriers want them in federal court? Well, 3 reasons, I think. They ultimately, if they get it to a jury trial down the road, they might get what they feel is a better jury pool, a little bit more conservative, maybe a little more pro-insurance type of jury pool. Second, that they know the federal courts are flooded with these cases. And even though we've got a really strong statute in Colorado that prevents carriers, insurance companies from unreasonably delaying or denying insurance payments, judges have been giving insurance companies, in my humble opinion, pretty good rulings because maybe they feel policyholders aren't proving up the claim. So insurance companies like it. So they're pulling these cases into federal court. And third, they're winning them. I mean, let's just be honest. They're winning them. Our client Sunflower had a policy term to which you refer that said prompt notice, but the federal judges are making rulings about what's reasonable. And so it's in their discretion. They're not going to leave that for a jury to decide. So one of the issues that comes up is from the time the storm hit, how long do you have? That's A. Versus B, I would argue that, a policyholder can only report it once they know or should have known. Like they should have reasonably known. But is that reasonably known what the federal courts are applying to their decisions on whether the policyholder gave prompt notice? Are they using that standard, Lee?
No, we don't know what standard they're using. I mean, in the Sunflower case, one of the facts that they took into account is that when a board member was on vacation, their car, or when they came back, their car had hail damage. That doesn't mean that the roof, or that we don't believe that it causes or it gives enough information for the board to have the roofs of a community fully inspected to where they should know there's damage that occurred.
I'm really glad you brought that up, and I want to come back to the car damage because I knew that board member very well, and I'll get back to that in just a second because it really shows how complicated this issue gets. But here's the thing I would say, what I just asked you, judges are saying that prompt notice begins from the date of the storm. And they don't care when you knew or should have known. It's just how many months did it take you to find out that there was hail loss. And a lot of people ask us, well, we had a hailstorm, but we really didn't see it till 6 months later. We looked up, there was some hail strikes on a downspout, but unless you were just looking at it at the right moment, the right angle, you might not have noticed. So what do you do now? That's one of the things I want to talk to you about to help people out there in their communities figure it out. The problem in this case was there was the hailstorm, no doubt about it. Community didn't really see the hail damage till they saw downspouts that were harmed about 8 months later. But there was evidence, like you said, that one of the board members had hail damage on her car. So the theory was, why didn't she talk to the other board members about the damage? Well, her testimony in the case was she wasn't around at the time. Her car was there, but she was out of state. But those are some of the issues we're facing. So one of the things that we thought it would be good to do with that is now hail season's about to hit. What can communities do right now to maybe somehow protect against this unfortunate situation where they might not know they were damaged till later? What would your input be? And I'll add on to it from what I've seen.
And it's frustrating because it really increases the cost to associations. The safest.
What do you mean by that?
What I mean by that is the safest way to protect the association is every time there's a hailstorm to get some type of specialist to come out and inspect the roofs. And that's going to be a cost. It's going to be a great expense if every time there's a storm or every time there's a hailstorm even close to the area, and you may not know if it actually hit or not, that you have to spend money to bring somebody out to inspect.
What about drones? We got a close friend, Austin Jones. He has his drone license. Can't we just fly some drones over these multifamily communities, see if there's hail strikes?
Again, first, how many communities actually have drones? Second, who's going to look at it to make a determination if it's hail damage or something else? Or when it occurs, you're going to still have some type of specialist provide that information. Well, and the insurance carriers, though, have those specialists. For some bizarre reason, they're called independent adjusters, which we all know they're really not independent. That goes to the next issue that has come up in especially the federal courts is the bias arguments that the insurance carriers are now raising with regard to public adjusters, contractors, roofers, and others that are involved with an association side of the claim. Do you want to explain what we're dealing with there?
Yeah, I think it's as simple as this. And in all fairness to the insurance side, they've kind of learned a lot about the homeowner association industry, who works with who, are there incentives to work with some people, and they've kind of figured that out. For example, public adjuster gets a percentage of what he or she might be able to achieve in increasing an insurance claim when there's a dispute. And then the insurance company might try to link that to any incentive a community manager gets for handling the claim, to then who did they choose as the contractor. The big debate is always who gave the estimate, who are you going to hire to fix that hail damage. And now the trend is, well, their estimates are too high, so all of you kind of figured out a way to try to quote unquote game the system. And I got to tell you, the argument's working. It's working. So here are the things that I think you and I feel very strongly about where we can help communities now that it's hail season. I hear what you're saying about it's an expense to have something checked out if you've had hail, but I think there's different ways to go about it. I think board members can take on a little bit of that themselves, go around. I mean, hail damage, you're usually going to see it somewhere, and then maybe it's worth, I personally believe it's absolutely worth to preserve your insurance claim, to pay some money, to sometimes have somebody take a close look, maybe your typical roofing contractor. And then when it comes to finding, and once you know you have the damage, and you got to choose somebody to fix it, whether it be a roofing contractor, fire loss restoration company, some of the business partners that we know through CAI that do that work. I think one of the things that's really crucial is that communities should still engage in their normal process where they get 3 bids, try to figure out, what really is a competitive but the best price for the job. Can you add on to that with all your experience over the years with choosing a contractor?
And price isn't always the end all.
Sure.
Comfort, competence, etc. Just a number of different factors that can be taken into account. Let me just sum up that the board should follow its fiduciary obligations. It can rely on experts and should rely on
Absolutely.
Consultants, third parties. It should definitely consult with its legal counsel, its general counsel, as to what it should do after a storm hits, especially if they have questions. Put it out to owners to identify, hey, we had a hailstorm. Are there any leaks? Are there any problems? Is there anything out there that anybody's dealing with specifically? Is there any hail damage that could be visible or possible hail damage that's visible? And then go through the necessary process to determine if there truly is damage to the community that would be an insurable covered event. And I mean, that's really what the associations need to do to protect themselves.
Couldn't have said it better.
So we thank you for joining us for HOA SOS, and join us for the next one. We look forward to keep providing these to you.